Let's see.
We'll make sure that we look at the notes, Daniel.
Yeah, we'll make sure we get all that in.
Brenda's been taking notes about the whole thing for us.
The good news is it is a court, every question I had was about a court exhibit, so they don't go back anyways, so,
I show it during the defense.
huh?
I show it was during the defense
Okay.
opening.
So whatever that was, all right, if still requested, I mean, I don't know that it's, I don't know. Anything else?
Nothing to say.
All right, we'll bring them in? Are you're using this then? Okay, I'll have to relook. Kate,
Your monitor works.
oh, okay, and I can see all the jurors.
Right, your monitor works, but don't touch nothing. I got it working.
Thanks. Thanks. Tricia's on standby just in case. Okay, yeah, you can bring them in. Yeah, that'll work fine, because I'll be able to see them and I can see
And
them.
they'll be up on the big board.
Cool.
Sorry.
All right, you're good, you're right. I'm still not as bad as Judge Tepper always was. Oh my gosh, you would start pushing buttons before anything would even happen. She'd push another button and it's like, whoa, stop.
Here we enter the courtroom, Your Honor.
Okay.
Jurors may be seated. All jurors are present and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? All right, we're going to get started again. As I indicated at some point, I don't know if it was yesterday or this morning, but I told you the order of things. Mr. Rosenwasser will now get his rebuttal closing. After that, we'll take a little break, and then we'll be giving you your final instructions. So, we're getting there.
This will not be long. At the beginning of the case, in opening arguments, and also during jury selection, we had a conversation about sympathy. So it's important to remind you all about sympathy as we get to the very end of the trial. Now, as you all know, sympathy should never play a part in the justice system. It wouldn't be fair to anybody. We would not want you to find the defendant guilty because you felt bad for the Olson family. Wouldn't be fair. But in the same vein, we don't want you to find someone not guilty because if for any reason you feel bad for the Reeves family. Now, sympathy, of course, is a human emotion, but it really does have no part in the criminal justice system. In fact, there's an instruction that Judge Barkle is going to read to you, and I'm just going to read it to you very quickly just to show you that it's in there. It says, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. So I know it goes without saying, and I almost feel bad saying it, I know that you won't let sympathy affect the verdict. You also know that the judge is responsible for any sentencing. You should not let that factor into your deliberations at all. You are the fact finders and the law appliers. Any sentencing issue is for the judge. Now, sometimes in trials what happens is this. Sometimes when you walk back in, and I know this might sound silly, but sometimes when you walk back in, someone might be in the audience. Might be a family member, might be a friend of either side. They might give you a smile or a glance, or sometimes people look away. Obviously, that does not have any impact on your deliberation. If any of us looked over and smiled, or at some point we looked like we weren't happy, the same for the defense table, has no bearing on the case. It would kind of be like putting it into the shiny object portion. It really doesn't mean anything at all in this particular case. So it's just very important for you to remember that. There were some comments that were made during defense counsel's closing that I do want to address. And then afterwards, we're going to fairly quickly just go through some things on the video, and I'm going to sit down. A couple very minor points, quickly address them. Defense counsel in his closing argument talked about DNA, how the defendant here could not be excluded. Well, there was a stipulation that was read, and really what the stipulation said, one part of it was there was not enough DNA on the phone to determine anything. Couldn't be included, couldn't be excluded, didn't mean anything. There just wasn't enough DNA on there. Doesn't really matter, because we all know based on the evidence, this phone was never thrown. The reason that the phone was where it was because either of two things happened, and no one knows. But the reasonable inference from the evidence is that when he reached over for the popcorn, it fell, or at the time he was shot, it fell. We know for a fact, though, with 100% certainty, that at no time was that phone ever used as a weapon, wasn't used to punch the defendant, and certainly was never thrown at the defendant. We know that for a fact because why? Because there's absolutely no injury. And even if that was some miracle, there's not a single person that saw an attack with a phone in the entire case, including his wife. We know with 100% certainty there was no phone at issue. The reason it's on the ground is because it was dropped at some point in time. That's it. There was another mention in closing argument from the defense counsel about how if you have a phone, you have this phone, it should be placed into airplane mode. Here's when that's important. If a phone is being searched for videos or for photos or for text messages, the content, you can save the content by putting the phone in airplane mode, or you put it into a certain box. If you're going to be looking at it for DNA, which in this case doesn't matter because it's just a shiny object, but if you were looking at it for DNA, you don't care if the phone's on or off. That's just a shiny object. Doesn't mean a single thing. Defense counsel talked about the timing of certain things, and we'll go through it on the video. But he mentioned that Nicole Olson stood up, and prior to the popcorn being thrown, she had her hand on Chad Olson and she was holding him back. Well, how do we know that's not true, that that's not the proper timing in this case? Number one, it's not on video. Number two, we go back to this point about eyewitnesses. Not a single person testified that there was a struggle where Nicole Olson was trying to hold back a charging Chad Olson. Who didn't see that? There's nobody in the entire case that saw that happening. And if it happened right in front of who? Vivian Reeves, Jane Roy. Nobody saw that. Why? Because that never, ever happened. You keep going back to the defendant starting it and the defendant ending it and a popcorn toss. And that really is this case, unfortunately, in the most simplest of terms. That's just what happened. It's sad, but that's exactly what happened. Defense counsel brought up, and it's kind of the reason why I brought sympathy up with you, all these things that the defendant had done. But it almost seems like the argument is this. Because in his past, he did these things. You know what? We shouldn't be having a trial. We shouldn't have you here as jurors to even discuss the fact that Chad Olson was unlawfully killed. He's excused from killing someone based on his background, training, and experience. And if you think about that, it's really an unbelievable argument. Now, in theory, we have laws in the United States that apply to every single person, in theory. From the President of the United States all the way down to Pasco County, every single one of us is bound by the same laws. You can't unlawfully kill somebody. It doesn't matter if you're the head of security at some point in your life of Busch Gardens. It doesn't matter if you're a police officer. It doesn't matter if you're a police officer today. Police officers are not given free passes. Nobody is ever above the law. Ever. You never start out one step ahead. Ever. It's as if to say, you know what? Chad Olson's life was meaningless because he graduated summa cum laude. Chad Olson's life is meaningless because he started the SWAT team that they use today. Chad Olson's life is meaningless because of the things he did at the Tampa Police Department. His life is meaningless. We shouldn't be here. That's sort of what's being said. Nobody ever starts above the law. Ever. Doesn't matter who you are, doesn't matter what job you have, it doesn't matter how much money you make. We're all judged equally under the law, no matter what. He killed another human being in a crowded movie theater next to his wife for no reason. Nobody should care what he did in his past. It's what he did on January 13th of 2014. He killed another man in a movie theater. Defense counsel talked about this first attack happening so quickly. It happened so quickly, he didn't even mention it to Detective Proctor, right? It's because it never happened. There was a conversation about Detective Proctor making a mistake because he never, ever had investigated a self-defense case. And I mean this as almost sarcastically as I'm going to say it. If he never investigated another case after that, he still has never investigated a self-defense case, because this is not a self-defense case. We're going to quickly go through the video. It's kind of like the cross-examination with the defendant.
May I just dim the lights for this?
Sure.
And when you get the computers, if you get the computers in the back, the MOV files are the ones you can open with QuickTime. Of course. Big line.
Yep.
There you go. Got the magic finger apparently. Everybody sees me okay? Here's the beginning, where we were talking about the reflection being the shoe. At no time was the reflection ever the cell phone. It has always been the shoe. It's not a coincidence. This is the very first frame where you can see the defendant's shoe as he's walking. It's going to go back and forth. Always motion. That's the shoe. Now, defense counsel talked about all these experts they were trying to get and all the money they were spending. They save a lot of money just by looking at the video, because it's very obvious that it was the shoe. What's the importance of this? The importance of this is the defendant and his wife coming into the theater. And it's really nothing in that they're just walking in the theater but the camera's able to pick them up because it's within the motion sensor area. Okay? That's the importance of just watching the very beginning. An almost insignificant event of two people sitting down triggers the motion-activated camera. Now, when you're looking at this, if you can look, you see the defendant is on the left side, and this is Vivian Reeves on the right side. In front of Curtis Reeves, you can see this is Nicole Olson. So they sit down, Nicole Olson is already there. Here's the next time we see the shoe. He's crossing his right leg over his left leg. There's the shoe. Okay? We don't have multiple cell phones. Nothing's happening. This is obviously his shoe. No speculation whatsoever that a phone was ever in play. Here he is leaning all the way in. Back appears to be fine there. Getting up to go to the manager. Now, for the next 3 minutes, he's at the manager's desk. He's returning back. Lo and behold, legs moving, there's a flash of light. No cell phone being thrown there, flash of light. Again, we don't need an expert to tell us that. Once the defendant comes back into the theater, as Derek Friedoff indicates, once again there's bickering. Chad Olson turns around in his seat. Coincidence? The defendant's right leg is moving. As he moves forward, you see the light. Absolutely, with 100% certainty, his shoes. And as we indicated, there is absolutely no way at this moment that a phone is being thrown as he goes forward. And his explanation for not reacting, not putting his hands up to his head, not exclaiming anything, not having any injuries was because he took karate some time ago. Now, what did the defendant indicate? Now remember, there's this first attack. There is no first attack. However, what the defendant indicated is that during this blue screen time, and remember we had a conversation up here, he's like, well, the camera doesn't hit row B. This camera is not picking anything up at all because there's not any type of significant event that is being recorded. So when the defendant wants you to believe that during this period of non-recording, Nicole Olson is fighting back with Chad, who's a raging lunatic, it's not picked up by the video because it's not happening, because there was no phone thrown. It's an absolutely made-up event that didn't take place. Now, the other important part of this, I'll tell you in a second. So now he's reaching over, he throws the popcorn. The popcorn has now hit him. After the popcorn has hit him, the defendant is going forward. Now, there's another flash down here, which is obviously his shoe. He has been hit with the popcorn, the gun's at the hip, he reaches forward, and he shoots him. Popcorn, thrusts forward and shoots. Now, Roy Bedard. Let's talk about Roy Bedard real quick. Roy Bedard did testify 2 years ago in a case that I prosecuted. And what Roy Bedard does is he travels around the country, testifies for the state, testifies for the defense, and he educates juries on self-defense. Now, the unlogical or the illogical leap is that because Roy Bedard didn't testify for the state in this case, that means the defendant's not guilty. That's the extremely illogical leap. Because if you took that position, anytime somehow Roy Bedard becomes the person that is critical for any case. So for the rest of my entire career as a prosecutor, if Roy Bedard testifies in a case where I'm the prosecutor and he's on the defense side, I guess I should just hang it up, right? I'll just jump off the case then, because if Roy Bedard's on the other side, that means that person's not guilty. That's how illogical that argument is. Now, we know, based on the evidence, that this was, unfortunately, about popcorn because of the defendant's statement. But let's, for just a second, let's suspend the reality, because that's what the defense wants you to do, is suspend the reality that it was about the popcorn, and that it wasn't. What that means is, if you want to believe what Roy Bedard stated, and he wasn't asked, who knows if he knows anything about the defendant's statement about popcorn hitting him? We don't know, no one asked that question. We don't know where that information came from that he testified to. But let's just suspend reality because we know the defendant made that statement. If he started the process of shooting and killing Chad Olson, think about this. It's worse for him. Because what's happening right here? There's not a single thing that's happening here. So he made the decision to kill him for absolutely no reason. But in reality, that's not true. You have to suspend the reality. Because what happened was, after the shot, he made it clear why he did it. He had an explosive moment of anger. He was angry because of what happened with Chad. Because Chad was standing up for himself, was saying things about texting his daughter. He reached over, he grabbed the popcorn, and he threw it on him. And when he had his hand coming back, that's when he was shot. He was not about to attack him. There wasn't any imminent threat of death to the defendant. Wasn't any imminent threat of great bodily harm. I'm not going to go through all the jury instructions with you. That is this case. That is really this case. That's the end of it. There was a question asked by defense counsel, Detective Proctor. It's a series of questions. And when I heard them, I thought, that was a really great set of questions, but not for Detective Proctor. And I wrote them down, so I'm going to give you a version of it. If it's not exact, it's not exact. But it was a really good set of questions. But when I say them, I want you to think about it from the defendant's point of view, not from Detective Proctor's point of view. And this is what the questions were. Is it important to be right and accurate in a homicide? Dealing in possibilities is dangerous in criminal court because a man's life is in your hands. And that's really powerful. And that's exactly what was at issue in this particular case. The defendant here had a man's life in his hands in a movie theater on January 13th of 2014. Chad Olson went to the movies and he never came out of that movie theater. His life was taken from him. It was an unjust shooting. He didn't deserve it. Not under that fact pattern in that theater on that day. We come back full circle. The defendant started it. The defendant ended it. And yes, unfortunately, a man was killed because popcorn was tossed. The defendant is guilty of either murder in the second degree or manslaughter. And he is guilty of aggravated battery as well. Thank you.
Thank you, Mr. Rosenwasser. Yeah, just push it back, that's fine. Great. All right, ladies and gentlemen, I know that was pretty quick. I do want to, I got to let you go for a short break. The lawyers and myself have a little bit more work to go over shortly before we begin your instructions, okay? So go ahead and take about probably 15 minutes, maybe a little longer, but Deputy Martin will come and get you when we're ready. Probably at least 15 minutes, and then we'll be ready to start with instructions, okay? Remember my instructions during the recess. All right, thank you.
All rise for the recess of the jurors for 15 minutes.
Are you gonna, you're not using it anymore, right? Yeah, if you, it doesn't matter. Well, I can't see, yeah, I can't see the fence, so, yeah, if you could go ahead. Go ahead, uh-huh. All right, council, I have in my hands what I believe to be the final version of the instructions. I want to go through them. I'm not going to read them line for line. I'll do that in a few minutes when the jury's here. But I'm going to reference each page according to what it is, and I'm going to be looking at the page. I haven't seen any typos or issues or problems, but let's go through them one more time. Make sure that we're all have the same order. All right, so I'm going to start with the first page is Introduction to Final Instructions, one sentence instruction. Same with Statement of Charge. We've got murder in the second degree and aggravated battery. Third page is Intro to Homicide. We got second degree murder at the top, and then all of that. Is there any questions about the body of that?
None from the state.
We don't have any.
Okay. So that leads into the murder in the second degree instruction.
No objection from the state.
None from the defense.
Okay, that looks good, that one, I don't see anything there. And that is followed by possession of a firearm and discharge. That's got all of the language in there. Okay, so then we go to the lesser 3.4 lessers, and the lesser indicated is in murder in the second degree is manslaughter.
And I just thought of a page that we don't have.
What?
I don't think we have, after aggravated battery, the lesser page that says the lessers of
Oh,
aggravated battery,
okay.
felony battery, and battery.
I knew, that's been nagging at me, you're right. I knew there was another lesser somewhere of this one. Okay, so that's 3.4, and we've got,
So we'll have to have someone make that one up.
yeah, we'll need that. All right, so that's going to go after the aggravated battery anyway. So manslaughter, that's followed by the manslaughter instruction, which is 2021 version.
No objection.
Good on that one? All right, and that is followed by aggravation of a felony with a firearm.
No objection from the defense.
No objection.
Okay. Then we have justifiable use of deadly force. And you guys have all gone over that extensively, I know.
Correct. State has no objection to this.
Okay. All right, the next one is battery, bat 65. And that looks, no objections on that one.
Correct.
All right, and then we've got the aggravated battery, the, of Chad.
That's Nicole Olson.
The one that I have is,
Oh, you were going to...
It's a chat, it's part of the justifiable.
Right.
Right. I thought we did. Okay, so batch 65, then that aggravated battery.
Right.
Okay.
and then the, another ag bat with Nicole.
Yes.
Correct.
Okay. And yeah, we need the lessers.
After that aggravated battery is the possession of firearm and discharge causing great bodily harm or death.
Okay, okay, so that sticks with the ag bat.
Then after that, we need the lesser.
Then after that is the lesser.
Mr. Funderburg, I think, is doing that right now.
Okay. So that'll be felony battery and battery. Correct, okay. So we have both of those. We just need the lesser. Any problem with the felony battery or the battery?
No, Your Honor.
All right.
No, Your Honor.
Then comes the transferred intent, and you both worked on that one, so it's, should be good.
Yes, Judge.
All right. Then plea of not guilty. And that shouldn't have had any changes to it. It all looks good.
We added shall, we all agreed on.
Oh,
that.
that's
That-
right,
that's
yeah.
That's in the instructions.
Yeah, correct. All right, and weighing the evidence, looks like we've got a total of 6 there. That all looks appropriate.
We had no objection to the 6, I don't think the defense did. We
Yeah, you talked about those.
Discussed those yesterday.
We've got number, quality, then law enforcement witness, expert witness, defendant witness, proper to talk to lawyer, and then your own conclusion. All right. Defendant's statements is in there.
In my copy, I don't know what the court has. I have him and her.
I do too. Anybody worried about that?
I'm not. If we wanted to make it perfect, we would take out the her, of course.
Right. And take out the brackets.
Yeah, well, let's do that.
Okay.
I'll give it Mr. Funderburk.
Okay. Rules for deliberation. You know, we could really take out, well, I'll just leave it, number 7.
Yeah, we could take that. I mean, no one would probably think about it because it didn't happen.
Right, but,
It would be better to take it out, I think.
yeah,
But I don't know
Yeah.
if that's part of their note-taking, I'm not, I understand I know what it means legally, but, I would just, there's no harm in leaving it in.
I don't see any harm in leaving it.
I don't either.
Okay, I'm good with it. And then there's not much you can talk about on the cautionary instruction. Single defendant, multiple counts. Would that, it doesn't matter. I was gonna say that might do better in front of the cautionary instruction, but,
I don't know where it goes in the book. Wherever the order is in the book
yeah,
is where it should
I
go.
know.
Well, let me read the book.
I think it goes before the cautionary. Usually the cautionary and those are the last 2, but I may be wrong.
Well, Your Honor, on single count, now that I look at it,
Mhm.
because this is an issue of transfer intent, and then transfer intent which cuts the other way, if it's justifiable, the use of force,
Mhm.
must find Mr. Reeves not guilty on the count involving Mrs. Olson. The last line in single defendant, multiple counts, is a finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charge. So, I mean, that seems to imply, if somebody reads this, that there may be a conflict in getting the instruction that.
Yeah, the transferred intent.
Yes, Judge.
I don't think so.
Well,
Only because, let's just say hypothetically that they were going to go guilty on one. Then they can say
Yeah.
not guilty on the aggravated battery.
Right.
And if it does come back, then we know we just have a legally inconsistent
Right,
verdict, and then you know what you have.
right.
There's no
I
argument
think, the only other option I would think, you'd almost have to say unless you find that transferred intent applies,
there.
but,
Then it gets,
Yeah, it gets
right,
confusing.
that's getting, I'm okay with leaving it just as it is. And if there's an inconsistent verdict,
legally inconsistent.
legally inconsistent,
so just-
it'll be adjusted accordingly.
I understand we're requesting that that line be struck. I understand the court's ruling, but that's what we're requesting. Certainly if it ends applicable to it, must be considered separately and a separate verdict returned as to each. So I think that says it, and I think, without putting the language of transferred intent, since we already have that instruction, that last sentence, if that's struck, that cures it.
Yeah, but, I mean, just think though, that if that would totally not apply if they found Well, I don't know. You know, they could find
Well,
not
then that-
guilty as to,
Right, that's the issue. They, you know, let's say they check, let's just say they find the second degree murder was justifiable. Then they're going to find, or make a finding that Mr. Reeves is guilty, but for some other reason other than transfer to 10. I mean, I don't know.
Well, then it would be a legally inconsistent word,
Right.
so we couldn't do it.
I
right,
understand.
right. That's
It's correctable.
uncontroverted.
Okay.
If that's how it, if they find it to be justifiable, then they can't find guilty on the ag bat.
I know.
So,
Okay.
that's on the
That's our
record.
objection.
Okay, I get it. I think if we change this one, we're asking for a lot of confusion. And I know that's not typically a reason not to, but I think it's a pretty good reason not to, with the understanding that we have a perfectly lawful remedy should that
Immediate
situation arise. All right, so anybody find where they're at? Should the cautionary instruction
I'm
be?
looking now.
I don't think it really matters, but it just, I don't know, I seem to think remember it going before the submitting.
Right, because submitting is in closing, so definitely before that one.
Oh, yeah, but it seems like that's the one that goes before. I don't know, what I'm saying is, I don't know if it goes before the single defendant, it just seems to flow better with the
After.
final, yeah,
Right, it
It
looks like.
goes after, I found it.
okay, good.
Right
After the
before.
questionnaire instruction, that's when you go through the verdict form.
Oh, it doesn't say that on there. Oh, I would have been lost on that.
You know
Where?
what, we're missing that page.
Yeah, where is that?
3.12, we're missing that whole page.
What page
Okay.
is that?
3.12,
What is that?
verdict. And the judge reads how the verdict form goes.
Yeah,
Must have left that out of the package.
Yeah, we need that whole one.
yeah, I would have been lost there for a minute. Because it says read verdict now. Read verdict form,
Yep, so we need that page, and then the verdict form we all have agreed on.
okay.
And after that, goes single defendant, multiple counts,
Yes,
and then submit a case to the jury.
okay.
So we have, what, maybe 3 pages we need to correct?
All right, so we got that one instruction needs to go in there. Is it just 3? We have we're not doing anything with that single defendant, multiple counts. We need the lessers for ag bat, and what else?
Page we're missing while reading the verdict.
Right, that's 2.
We're taking out the her.
Oh, that's right, thank you. All right, and who's got these on their computer?
I think Mr. Thunderberg is doing some of them, right?
Okay.
Yeah, we can, Judge Weil, we can make a very quick motion that we're gonna make as well. It's, we're gonna renew our motion for judgment of acquittal.
Okay,
Same arguments that the government has failed at this point to present any evidence whatsoever to refute the justifiable use of deadly force in this case for Mr. Reeves.
all right.
And specifically with the instructions that everybody has approved, they have failed to meet that burden.
Any response?
At this stage, the court has heard all the evidence. There's ample evidence to support this case being submitted to the jury. We have proven all the elements for second-degree murder. We've had witnesses that have indicated that the defendant appeared grumpy. We have sufficient evidence that there was a significant period of time between the time that the defendant first had contact with Chad Olson Olson up until the point of the time of the shooting, sufficient to demonstrate enough time to develop ill will, hatred, spite, or evil intent, coupled with the defendant stating after the shot, words to the effect of throw popcorn in my face. With respect to the aggravated battery, under the transfer and intent doctrine, we have presented sufficient evidence for that case to go to the jury as well, as the defendant did intentionally shoot Chad Olson. Nicole Olson's hand was in front of his chest at the time of the shooting, and she did in fact suffer great bodily harm, permanent disfigurement, or permanent disability, or the defendant did use a deadly weapon, which would be a firearm.
Your Honor, if I may just be excused, let me go see if Mr. Funderburg can print up this introduction of final instructions that was left out of the packet that was provided to us by the state.
Okay,
I'll be back in a minute.
all right. I'm gonna deny the motion for judgment of acquittal. I find that the state has provided evidence to overcome the argument of the defense. Thank you. All right, so.
Judge, the only other thing that we probably ought to do in the French.
Ladies and gentlemen in the audience, in a few minutes, we're going to start jury instructions. During the jury instructions, no one will be allowed to enter or leave. So be comfortable or go ahead and go now, because you won't be permitted to come and go during the instructions. Thank you. How's it going?
Good, I'm gonna go check with him now, just.
When we have the lesser one that goes before the aggravated battery, that will make it, I knew that didn't flow right. You went right from the ag bat that hooks with the justifiable use to Nicole's ag bat. It just didn't, I knew there was something missing, so that'll make it much better.
See what the time, how they're getting along.
Okay. Connie's on standby to make all the copies, so. Corporal? the last. If you guys want to look at this. possession of a firearm and charge, excuse me, when there are lessers for manslaughter, of second degree is manslaughter, then the manslaughter instruction, then aggravation of a felony by carrying a firearm, then justifiable use of deadly force, BAT 65, ag bat of Chad, then when there are lessers for the aggravated battery of Nicole, felony battery and battery, then the wait, that needs to go behind, no, that's right, so,
No, there's an aggravated battery for.
right, that goes first, right.
That goes first.
Okay, so we do have two ag bats in a row
There's an aggravated battery that,
of Chad,
That's right. Well,
right.
what you do is, I think when you're reading the justifiable use of deadly force, when you get to that crime where it says an individual felony battery in 65, then is when you read the
Right.
elements of it. So when you look at justifiable use of deadly force,
Oh, does it have a spot in there?
when you, like right after you read the crime, to commit the felony offense of battery on a person 65 years of age or older, then I think you say that the court will now instruct you as to the elements of that crime.
Okay, that makes sense.
And then you read the elements for that crime.
And then the
Then
same,
then you go back to the justifiable use of deadly force instruction, and then after you read the aggravated battery, then you say, I'll now read through the elements of aggravated battery.
okay, fair enough?
yes,
You good with that? All right. So, so after the ag bat
on
with
Mr.
the,
Reeves,
yeah,
then there's the,
the ag bat of Nicole,
yes,
So
and,
after the aggravated, well, yes, I know we're going in order, but after the reading of the aggravated battery, you go back to the
right,
justifiable.
I'll finish that, and then I'll skip those two and go straight to the ag bat of Nicole, and then after that, there will be lessers of that ag bat, which are,
There's the 1020 life instruction after the aggravated battery.
oh, I don't have that in my package, do I?
you did.
There it is, yeah, it was out of order, okay, so, that goes, the 1020 life goes right after the ag bat,
Yes,
Correct.
Nicole's ag bat, and then when there are lessers,
right.
okay. And then those lessers are
Felony
instructed,
battery and battery.
yep, then transferred intent, plea of not guilty, weighing the evidence, defendant's statements, rules for deliberation, single defendant, multiple counts, cautionary instruction, verdict, and submitting case to jury.
The single defendant multiple counts goes after you go through the verdict form.
Okay. Okay. So, let's, cautionary, yeah, cautionary comes
Cautionary instruction,
before
verdict.
verdict. Yep, you're right, it
And
does. Then single, then submitting case to jury, okay.
Right, single defendant, multiple counts, and then the submitting.
Verdict, yep, right. All right. So, anybody have any comments, questions, problems?
I think just for the record, the state will say that the state's reviewed all the jury instructions and we have no objection to them.
Okay,
No objection for the defense.
all right, very good. Then, when we bring them back, I'll begin instructing them. They'll each have a copy, as will all of you. I need 16 copies. Why? Oh, court reporter, clerk, okay. So I need a total of 19, so that'd be 18 copies, right? We got one? Okay. Well, I'll instruct them. At the end of the instructions, I'll call you all up and ask you if I read them as we agreed, and if there's any objections that aren't of record, you'll step back, then I'll release the alternates, and then they'll go.
When you want to do the computers,
Oh, yeah.
when you talk about the jury, the evidence will go back with you and the
Yeah.
things we have.
The deputy clerk will be sure that all of the items in evidence are gathered together along with the verdict form. And I'll tell them then.
And that the exhibits on there are preloaded with
Uh-huh.
what's there, so they don't have to.
Right. Look for them.
Right.
Just take anything out of, it's already on there, right? Okay.
And Judge, what evidence is staying back?
The gun, yeah. All right.
Your Honor, just spoke the jury up, if I may, that the videos from the defense have submitted, the videos that the state has submitted, along with the audio recording, there are other items of evidence that are not on them. So in other words, if they want to look at photographs, for instance, that were entered into evidence, they wouldn't find that on the laptop.
Okay,
They're just a video and just the audio recording of the interview. So they have to know that to find something else, they're going to have the photos and other items back there, with the exception of the firearm that you're going to talk to them about.
only the videos and the audio
The interview
Statement.
of Mr. Reeves.
interview of Mr. Reeves.
And that interview's on both.
Okay,
And Judge, they need to check all that unless they,
yeah. You guys will check the evidence before it goes back, right? Or look through it?
Yes, Your Honor.
Tammy,
Somewhat
were you able to go
order.
through that list?
yes,
So that's
yes and no.
our yes and no?
Uh, Are you giving it to them in a box?
Yes, Judge, it's on the box.
All
And it's
right.
somewhat in order of each thing. These have the photos.
Okay, so I'm going to say photos, and the other exhibits will be given to you in the box, provided to you. Okay. All right, so while she's making those copies, if anybody needs to use the restroom, which I'm going to go real quick, it'll take just a few minutes, and then we'll be ready to go.
I just need to go once. That's fine. I mean, I got some of them marked, but now I got questions, so I'm like, I'll wait. Okay.
Yes. Oh, okay.
Detective Smith told me that the batteries, because of their age, I mean, they're very low.
Excuse me. Oh, yeah. Good. Thank you, Connie. Have a good weekend. Thanks. All right. Verdict forms, yeah, right here. You can get them, Tina. They're not answering.
Jurors in the courtroom, Your Honor.
Very good. Thank you, Deputy. Thank you, ladies and gentlemen. Deputy Martin's about to hand you all copies of the instructions, and I'll get started. Thank you all for returning. Were you all able to abide by instructions during that last recess? All right, thank you. All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Statement of charge. Curtis Reeves, the defendant in this case, has been accused of the crimes of murder in the second degree and aggravated battery. Introduction to homicide. Curtis Reeves is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Chad Olson was killed by Curtis Reeves, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Excuse me. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Curtis Reeves may be found guilty of murder in the second degree or any lesser included crime. Murder in the second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Chad Olson is dead. 2. The death was caused by the criminal act of Curtis Reeves. 3. There was an unlawful killing of Chad Olson by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Possession of a firearm and discharge causing great bodily harm or death. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm or the death of Chad Olson, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find Curtis Reeves guilty of murder in the second degree with discharge of a firearm. If you find that Curtis Reeves committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find that Curtis Reeves guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to, expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Chad Olson is dead. Pardon me? Yeah. And 2, Curtis Reeves intentionally committed an act or acts that caused the death of Chad Olson, or B, the death of Chad Olson, that was A, B, the death of Chad Olson was caused by the culpable negligence of Curtis Reeves. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Aggravation of a felony by carrying a firearm. If you find that Curtis Reeves committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, or used a firearm, you should find him guilty of manslaughter with a firearm. If you find Curtis Reeves committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, or used a firearm, then you should find him guilty only of manslaughter. Justifiable use of deadly force. An issue in this case is whether Curtis Reeves acted in self-defense. It is a defense to the crimes of second-degree murder and manslaughter if the death of Chad Olson resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Curtis Reeves reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting an attempt to commit the felony offense of battery on a person 65 years of age or older upon him. And I'll now instruct you on the elements of battery on persons 65 years of age or older. The crime of battery on a person 65 years of age or older involves the following elements. 1. Chad Olson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. And 2. Curtis Reeves was at the time 65 years of age or older. It is not necessary to establish that Chad Olson knew or had reason to know the age of Curtis Reeves. Unintentional touching or striking includes situations where Chad Olson knows that a touch or strike is substantially certain to result from his act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of an aggravated battery against himself or another. And I'll now instruct you of the elements of aggravated battery. The crime of aggravated battery involves the following elements. The first element is a definition of battery. 1. Chad Olson actually and intentionally touched or struck Curtis Reeves against his will or intentionally caused bodily harm to Curtis Reeves. 2. Chad Olson, in committing the battery, A, intentionally or knowingly caused great bodily harm to Curtis Reeves or permanent disability to Curtis Reeves or permanent disfigurement to Curtis Reeves, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Unintentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as a part or as an extension of the person. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing Curtis Reeves need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Curtis Reeves must have actually believed that the danger was real. If Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Curtis Reeves and Chad Olson. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you shall find Curtis Reeves not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Curtis Reeves was not justified in the use of deadly force, you shall find him guilty if all the elements of the charge have been proved. Aggravated battery. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. 1. Curtis Reeves actually and intentionally touched or struck Nicole Olson against her will. 2. Curtis Reeves, in committing the battery, A. intentionally or knowingly caused great bodily harm to Nicole Olson, or permanent disability to Nicole Olson, or permanent disfigurement to Nicole Olson, or B. used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Possession of a firearm and discharge causing great bodily harm or death. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm or the death of Nicole Olson, you should find Curtis Reeves guilty of aggravated battery with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find that Curtis Reeves guilty of aggravated battery with discharge of a firearm. If you find that Curtis Reeves committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find Curtis Reeves guilty of aggravated battery with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that Curtis Reeves, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of aggravated battery are 1, felony battery, and 2, battery. Felony battery. To prove the crime of felony battery, the state must prove the following 2 elements beyond a reasonable doubt. 1, Curtis Reeves actually and intentionally touched or struck Nicole Olson against her will, and 2, Curtis Reeves caused Nicole Olson great bodily harm, permanent disability, or permanent disfigurement. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. 1, Curtis Reeves intentionally touched or struck Nicole Olson against her will, or 2, Curtis Reeves intentionally caused bodily harm to Nicole Olson. Transferred intent. If a person intends to shoot a person and in the process shoots a different person, the law transfers the intent to shoot the intended person to any person who was actually shot. However, if the death of Chad Olson resulted from the justifiable use of deadly force, then you must find the aggravated battery or felony battery or battery of Nicole Olson was also justified. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond the defendant's presumption of innocence. The state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you shall find the defendant not guilty. If you have no reasonable doubt, you shall find the defendant guilty. It is up to weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, the jury is not to discuss any questions that a juror or jurors wrote that was not asked by the court and must not hold that against either party. 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in any anything I may have said or done that may think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilt, it should be for the highest offense the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. I have them here. There's 2 of them. They will go back with you with the evidence. It has the caption at the top of the page, in the courts of the 6th Judicial Circuit and in Fort Pasco County, Florida, State of Florida versus Curtis Reeves. It's got the case number, and the first one is the information for count 1, murder in the 2nd degree, and it has verdict. We, the jury, find as follows. Check 1 and only 1 on this form by inserting a single check mark on the line next to the description of the verdict which you have found. And the first line is, the defendant is guilty of murder in the 2nd degree as charged. Under that, it says, if and only if you find the defendant guilty of murder in the 2nd degree, then please further find as follows. Check 1 and only 1. The first one says the defendant did discharge a firearm during the commission of the offense, and as a result of the discharge, death or great bodily harm was inflicted upon Chad Olson. The second one is the defendant did discharge a firearm during the commission of the offense, and the third one is the defendant did actually possess a firearm during the commission of the offense. Then you go to the next page. And it says, number 2, the defendant is guilty of manslaughter as included. And then it says, if and only if you find the defendant guilty of manslaughter, then please further find as follows, and check 1 and only 1. Well, there is only 1 there after that one. The defendant did personally carry, display, use, threaten to use, or attempt to use a firearm. And then the third choice is the defendant is not guilty. So say we all, this 25th day of February 2022, then there's a line for the signature of the foreperson and the printed name of the foreperson. The second verdict form is for the second count, information for count 2, aggravated battery. It's got the same caption and the same thing, verdict. We, the jury, find as follows. Check 1 and only 1 on this form by inserting a single check mark on the line next to the description of the verdict which you have found. The first one has a line, number 1, the defendant is guilty of aggravated battery as charged. And then it's got the questions below that. If and only if you find the defendant guilty of aggravated battery, then please further find as follows, and check 1 and only 1. The first one says the defendant did discharge a firearm during the commission of the offense, and as a result of the discharge, death or great bodily harm was inflicted upon Nicole Olson. The second option is the defendant did discharge a firearm during the commission of the offense, and the third option is the defendant did actually possess a firearm during the commission of the offense. There's also page 2, the next page. That has the number 2 on it, and it says the defendant is guilty of felony battery as included, or number 3, the defendant is guilty of battery as included, and the fourth option is the defendant is not guilty. So say we all, this 25th day of February 2022, and again, signature of the foreperson and printed name of the foreperson. Single defendant, multiple counts or informations. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. Submitting the case to jury. In just a few moments, you will be taken to the jury room by the bailiff, and the first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or email communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, and if you wish to see the firearm exhibit, please request that in writing. You will also receive 2 computers for use in viewing the video exhibits and to listen to the interview of Mr. Reeves. One of the computers has the state exhibits and the other has the defense exhibits. Both have the interview of Mr. Reeves on it. Only the videos and the interview of Mr. Reeves are loaded on the computers. Photos and the other exhibits will be provided to you in the box. And when you get the computers, when you get them back there, please plug them in immediately because the battery will die quickly. So go ahead and plug them in as soon as you get back there. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. And there are instructions on the top of each of the computers so you can tell what to do. It's pretty simple by all accounts. I think I could handle it myself. So I'm sure you guys will be able to figure it out. If you can't, simply knock on the door and write your question and hand it to the bailiff. She can't answer any questions except for, is there more toilet paper or something like that, but anything about the case at all, she can't answer any questions. So just write them on a piece of paper as indicated in the instructions. All right, counsel approach. First of all, well, we'll get to that in just a minute. All right, it's time. Let's see. I have some alternates to excuse. That would be juror number 7, 8, 9, and 10. It is the duty of the court to release you from further service on this jury. Because of the order in which your names were drawn, you have been seated as alternate jurors. It was necessary that we have you serve in case one of the other jurors was unable to complete his or her service, and fortunately, they have all been able to complete the trial. I can't let you go back in the jury room with your former fellow jurors, but you're welcome to remain here in the courtroom if you wish to hear the verdict. If not, you are free to go. And on behalf of all of us, I can't even tell you, I'm going to get choked up, so I'm just going to make it brief, how much we appreciate you guys. This has been a long and tough trial, and we all appreciate your attentive attention and attendance every day. And I know it's been a lot of time out of your lives, and this goes for the rest of you too, but I'll talk to you later. But I just want to thank you very much for your time and attention. So you are now discharged from your service as jurors, which means you can do whatever you want. Just leave your badges with the bailiff, and did you give them? You got them? Okay. All right, so you can, you'll go with Deputy Martin real quick, and you can either stay or go. Just let him know back there. Thanks, you guys.
Leave your stuff. Oh, yeah. You got your badge? Just drop it in that chair. Okay? There you go. I'll do that. Just drop it in that chair and zip this is for you. That's for you. You're very welcome. Thank you. Here. That's for you. And this is for you. Thank you.
All right, and there's a couple errors that we noted on the instructions. So if you could pass your instructions up, and I'll write on them real quick. It's just a couple of words and a number that needed to be put in there. And while we're doing that, you can probably take them back, and we'll assemble the evidence and the computers, and you can go back and get comfortable. And Tina will bring all the stuff to you shortly. We'll wait just a minute. Yeah. All right, you guys can go deliberate shortly. Here, I'll give 3 to each table. 3 to each table.
Yes, okay. For them to fix the
Yeah.
table, okay?
3 to each table.
I'll just need mine fixed too when they
Which one?
whatever they're fixing.
Oh, yeah. Mine too. I'll show you if you want.
With the verdict form or no?
Verdict forms are right here. It is hot in here. Yeah, give them to those. All right, so on the manslaughter, Yami, manslaughter. Oh, no pages. Right, the number 2 next to the A. Okay. And let's see. I think the next one's on the verdict one. Yeah, it is on the verdict. It has this on the verdict one. That's one of the Read right through. Highest offense on.
That's it?
That's it. Was it just the two changes? Mr. Rosenwasser? Was there just the two changes? Okay, thank you.
I need to get that other three and then get changed.
Jury instructions, and it's all, and verdict forms all going back?
Yes. at this
Okay.
time, Your Honor.
Just let me know when you've delivered that to them. What did it say? The jury is retired to deliberate. Are there any other matters that require our attention at this time?
Nothing stated.
No, Your Honor, not from the defense.
All right, then we'll stand in recess and await the call of the jury. All members of the audience will have to wait outside somewhere in the courthouse, wherever you wish to go, but you can't remain in here. Counsel can remain in here if you wish. And of course, Mr. Reeves and probably his family can wait, but everybody else will have to go outside. All right. Thank you.